I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class, or Leg-Reg, about the case Exxon Mobil Corp versus Allapattah Services Incorporated. This is a U.S. Supreme Court case from 2005 that really highlights kind of the difference between modern textualists and those who want to use legislative history. Quick word of introduction for my students. This is a hard case. It's kind of complicated, and I'm going to try to work you through it and help you work through it. It's difficult to read. We're not reading this case to learn a rule of law or the facts. Actually, we're not even going to talk about the facts this time at all. This is one of our cases that we're studying just to see how courts use or abuse legislative history. And this also highlights, it's one of our cases where we have contradictory legislative history. So both the majority and the dissent have legislative history that supports their view of what the statute means. And so that's what we're really looking on. Also, as a preview, why is this case so complicated? Because partly because not only do we have contradictory stuff, but the legislative history, the comments before Congress passed this law, discusses prior Supreme Court precedent and was expressly trying to undo or reverse or change the law because Congress didn't like what the Supreme Court had done. And so the question then is, we're all used to in law school of courts interpreting their own precedent, but how should they interpret Congress interpreting their precedent and deciding whether overruling one precedent kind of reinstates the prior precedent that was in existence before that. And I know that's a lot to follow, but that's kind of where we're going in this case. So let's look at what happens here. So this is a case that could be in your civil procedure casebook course or course almost, because it's about federal court jurisdiction. So forget about the facts for a moment. This is a case about whether federal courts have jurisdiction. And specifically, keep in mind from your Civ Pro days that generally federal courts have a jurisdiction over two major types of cases: federal question cases and diversity cases, where you have people, parties from different states. And remember, there's usually an amount in controversy requirement for diversity jurisdiction. But you don't always have to have diversity jurisdiction. Sometimes it's a federal statute we're applying or a federal question. So a question may arise then of whether or when a federal court has supplemental jurisdiction over claims that don't independently satisfy federal jurisdictional requirements. In other words, what if you have a case that involves multiple claims by the plaintiffs or multiple claims in a counterclaim, and some of those are not really federal question or wouldn't meet diversity and jurisdiction requirements, but other claims in the case do. So that's our jurisdiction question, and I'm not going to answer that for you. You can ask your civil procedure professor. So the question is whether a federal court has diversity jurisdiction over a class action lawsuit when some, but not all, of the plaintiff's claims meet the amount in controversy requirement for diversity jurisdiction. In other words, so I want you to imagine a class action. You have a big class of potential plaintiffs. Usually only one or a few are named, and then we have a whole bunch of unnamed class members. But a lot of those class members, their independent losses or harm suffered wouldn't meet the amount in controversy requirement for diversity jurisdiction. So if we get one who does, can we get into federal court? That's part of our question. So before 1990, the Supreme Court had answered this question as no. There was a 1973 decision, Zahn versus International Paper Company, where they said no. In a class action lawsuit, if you're going to get diversity jurisdiction, then every plaintiff's losses or demand has to meet the amount in controversy requirement. Well, The lower courts over the years thought the federal courts maybe could exercise supplemental jurisdiction in federal question cases, where the plaintiff advances both federal law claims and state law claims against different defendants arising out of the same alleged wrongdoing. And so, in other words, we have this world of after 1970, between 1973 and 1990, where for diversity jurisdiction, every plaintiff in the case has to be able to meet diversity jurisdiction. And then the question was, what about federal question jurisdiction? Does every claim have to meet that? And so in 1990, in 1989, the Supreme Court sort of rejected this trend in the lower courts in a case called Finley versus United States. And so they rejected this sort of this jurisdiction that had been accepted under Zahn for federal, basically sort of the supplemental jurisdiction, over federal questions. And then right around the time that the court was putting out the Finley decision in 1989, Congress had created a commission to study federal courts and the jurisdiction issues that federal courts had. And so they were supposed to study the whole federal court system and propose some reforms for the court system. And here's a picture actually of the Federal Court Study Committee. And you can see Justice Rehnquist is actually sitting in the front row center. And next to him is Judge Posner, who was also a law professor at the University of Chicago Law School, a very, very famous, one of the most famous judges in the country at the time, Richard Posner. So this committee that you see in the picture here had some subcommittees that studied different aspects of reform, like this jurisdiction question. And Judge Posner, seated next to Justice Rehnquist in the front row there, and near the center, chaired this special subcommittee. And so they proposed expanding supplemental federal jurisdiction, that they were going to settle this question expressly. So the proposal appeared in the federal court's study committee's final report to Congress, which was published in 1990. And by the way, if you're a little bit lost, keep in mind that basically Judge Posner is saying, and his subcommittee thought that the Finley case that came out in 1989 was wrongly decided, and they were going to try to undo that. So then the next year, Congress passes a bunch of amendments to the federal jurisdiction statutes and basically adopted a lot of the recommendations of that study committee that I showed you on the last slide. And importantly, it added 28 U.S.C. 1367, which adopted with only slight modifications that we don't care about here, kind of everything that Judge Posner's subcommittee had recommended. In other words, Congress liked Posner's subcommittee's recommendations and bought it. So everyone understood that this whole point of the amendments was to overrule Finley, that unpopular Supreme Court case from the prior year. But the question then was whether, just to make sure you don't lose me here, or I don't lose you, is if we overrule Finley, do we put things back to the way it was before, which was kind of Zahn, that case from 1973 would have applied, or are we reversing that too and kind of like undoing all the prior precedent and just starting with a blank slate? And the Supreme Court here, and the case we're studying here, Exxon Mobil, says that that is what happened, that basically this overrules Finley and Zahn, which was the precedent before Finley. And so from a civil procedure standpoint, this means in diversity class action, you would only need one plaintiff whose claim exceeds the amount in controversy requirement. Now, the majority opinion by Justice Kennedy did this and said that they didn't need to look at legislative history because the statute was clear that it overruled both. They were getting rid of both Finley and Zahn, but the dissent and disagreed. And their main point of divergence is in the treatment of the legislative history. And by the way, that is why we're studying this case. So let's talk about the legislative history. We have a House committee report. Remember that House and Senate each have committees, and before a bill goes to the floor for debate and a vote, it spends a lot of time and in a committee that basically specializes in that area of public policy or law, and they put out the final version that's going of the draft of the bill that goes for debate and adoption, the vote, and also a big old committee report that's really thick, that is transcripts of their hearings and statements and conclusions by the committee and so forth. So we have two committee reports here. The Federal Court Study Committee, which was sort of this blue ribbon commission of federal circuit court judges and famous law professors and so forth, and then the House Committee Report, which is a subset of people in the House of Representatives. So the House Committee Report says that 1367 restores pre-Finley understandings of the extent and limits of supplemental jurisdiction, and would make only one small change, not relevant to this case, to pre-Finley practice. In other words, we're back in Zahn land, so Zahn would apply, but Finley doesn't. And the committee report said explicitly that 1367 would not affect diversity-only class actions, and specifically said it would leave Zahn, that 1973 case, intact. In other words, we were really just undoing the Finley case and putting it all back to the way it was like the day before that decision came out. So that's the House Committee Report, and I hope we can see that's completely the opposite of what Judge Posner's Federal Court Study Subcommittee report said. So Justice Kennedy, for the majority, asserts that the legislative history is often itself ambiguous. And this is a very important point from the case, is that we're usually using legislative history to resolve ambiguities in the statute, figure out, well, what did Congress mean by this ambiguous term or phrase? And so what happens when the legislative history is also ambiguous? Do we use statutory construction to figure out what the legislative history means, or what? And here's the example. Though the House Committee report seems like clear evidence that the drafters understood the language not to overrule Zahn, the report of Judge Posner's subcommittee, which was responsible for drafting the language that Congress actually adopted, said that the language would have the effect of overruling Zahn. Justice Stevens strongly disagrees with this idea that the legislative history is ambiguous and therefore it kind of cancels each other out, because he thinks we should just give a lot more weight to the House Committee report than the report of Judge Posner's subcommittee. By the way, there's a little bit of political difference here. Justice Stevens was a lefty, one of the liberals on the court, and Judge Posner, at least at the time, was notorious for being one of the most conservative circuit court judges in the country. Not the most conservative, but he was a conservative, and he was appointed by a Republican president and so forth. And so, but Justice Stevens basically says the House Committee are actual members of Congress, and nobody on this, on Judge Posner's subcommittee was. That's a bunch of judges. So it makes sense to Justice Stevens to look at what some congressmen thought the statute meant, for an indication of congressional intent. And the committee report is also, he says, what the House Committee report is whatever other members of the House would have read. He thinks that they wouldn't have read Judge Posner's like blue ribbon panel about how to reform the judiciary. They are used to reading committee reports if they want to know what the statute means before they vote on it. And so the court should give more weight to that. So please note here, part of the takeaway from this case is that Justice Stevens in his dissent has sort of this traditional view that there's a hierarchy of legislative history materials. In other words, some should be given a lot more weight than others, and he has this clear hierarchy in his mind. Justice Kennedy seems to reject, or at least de-emphasize, these traditional presumptions about which sources are more authoritative. An important aspect of Kennedy's emphasis on the ambiguity is his concern that looking to legislative history loosens constraints on judicial discretion and provides a pretextual justification for judicial activism. Also, note Justice Kennedy's quotation of Judge Harold Leventhal's famous line that the judicial use of legislative history is like looking over a crowd and picking out your friends. That is, we emphasize only certain pieces of the legislative history that support the judge's view. I call this in my classes the friendly faces problem, that when you look at the legislative history, there might be something for everyone. And instead of saying, well, I guess that cancels each other out and we're just going to have to go back to interpreting the statute, we pick the phrases we like that support the court's view and say, see, this is what Congress intended. Now, this is a part of the case that's hard for students to follow, I think. We have this discussion of 3 law professors who were also worked with the House committee on drafting this statute. So what's kind of confusing is that the House committee, just as Stevens is all like, so this is made up of congressmen, but they actually brought in some law professors to help draft the statute. They committed to the committee, they contributed to the committee report, and then they published a law review after the fact saying that even though the statute could be understood to overturn Zahn, that's not what anybody on the committee was thinking. And they were worried that the language would be misunderstood by courts. In other words, so they published this law review article after the bill has been signed into law and say, we were there in the room and this is what it really meant. And we're worried that you're going to misinterpret, courts are going to misinterpret this because what we passed, we weren't that clear in our wording. And Justice Kennedy's view, this is exactly what we're afraid of with legislative history, that some people anybody who wants can come along after the fact and say, I was there and this is what we were all thinking. They can try to fix language they don't like in the statute by adding something so then the question is, does this law review article count as legislative history if it's a recounting a story of being at the subcommittee? And so this sort of confirms the textualist's worst fears about circumvention of the constitutional lawmaking process. Justice Stevens has an answer for this, by the way. He says the professor's point is not that the correct reading is theirs and that it overrules on, but that the committee report was supposed to undo that result. Their report was that they realized the language was susceptible to 2 different meanings, one of which they intended and the other which didn't. And so what's the harm in them adding some clarification? By the way, we know this could be read 2 different ways. And just so you all know, we were there and this is what we thought it meant. Okay, that concludes our discussion of the Exxon Mobil case.